mere abstract ideas, and a way to think about an abstract idea is an algorithm, and they have a computer algorithm, are not patentable subject matter. It's mere manipulation of data or numbers. Okay, so that will not be patentable subject matter. So what often is, and it's sort of an interesting game you play with software, is the more specific the inputs. So let me take something. We could have an algorithm that does some sort of adjustment of numbers. Maybe it smooths out numbers and peaks. Okay, it's an algorithm. But I might apply it to image data. So if I can have some image data come in and now I apply the algorithm, and then I get a series of outputs, maybe I can get to a position where for image data, because I have specific inputs, applied to a more generic algorithm with an output, I might get a patent on that. Okay, the algorithm itself won't, but this idea, if I have inputs and outputs, I can sort of play with this idea of what may or may not be patentable. Alice Corp was actually to a way, I think, of more or less running a hedge fund. In this case, what the commissioner is talking about is that which already exists as an idea, if we take it and just do it with a computer, that's not going to be patentable. The mere fact that you now do it with a computer or do it with the web is not going to confer patentability. Now, it is true often, like in a chemical arts, I can take a composition and I can put it in a new environment. So maybe I have a composition that's great for toothbrushes, and I discover it makes a really great roller in a printing machine. I might be able to take that material and claim it within a printing machine and have a patent. But what it's saying here is a computer is not really a new environment. Merely doing it on a computer is not enough. There's got to be something more about the novelty. So this took something that basically people did by hand and put it onto a computer. And the court said, no, that's not patentable subject matter. And in a rare moment of unanimity, they agreed on that. So, okay. So, when I get a patent, what do I get? And I said this last time, I'm going to reiterate it again. If there's nothing else you take away from this presentation, I hope you take this idea. Okay, this is the most important thing you're going to take away today. A patent holder is granted a right to exclude others from using, making, selling, offering to sell. Okay, it's a right to exclude others. It's not a right to practice the invention. It's an odd concept. Most of the time with a right, you're given a right to do something. In this case, you're given a right to exclude others from doing, but it doesn't confer any direct right onto you. Okay, so it's a right to exclude others. So, let me give you an example, real life example. Someone created the tubeless tire. Tubeless tire is kind of a nice thing. Up to them, we had rim and an inner tube and a tire. Okay, and just like on your bicycle. Now, someone created the tubeless tire. And it was kind of nice, but you had to have a special tire. It had to have a reinforced bead, and the rim had to be airtight. So in the grand scheme of things, it was sort of an improvement, because you had two things instead of three, but you had to make special rims and special tires. Someone came along and said, gee, that's interesting technology. So there's patents on the tubeless tire. I think if I play with the belts inside this tire, I can make a better tire. And what they did was they adjusted the way the belts ran inside the tire, all the reinforcements, and they created what's the modern radial tire. And radial tires are better because they grip the road better and they last longer and they do a bunch of really positive things for tires. They got a patent on the radial tire. What did they get? They got a right to exclude others from making radial tires. Every time you made a radial tire, you inherently made a tubeless tire, because all radial tires are tubeless. So the problem was there's an underlying technology. So the first patent holder had a right to exclude people from making tubeless tires, which includes radial tires because they're tubeless. The second patent holder had the right to exclude others from making radial tires. Okay, you could make tubeless tires, but you couldn't make a radial tire. So it was a case where nobody could really do anything because they had those rights of exclusion. Now in the real world, what they did was they licensed each other, and they were all able to make tires and make money, which is a good thing. But it's that right of exclusion. So I want you to take that away as a concept, because it is almost inevitable at some point, if you really work with patents in your career, the question will get asked, gee, do we have a right to use, or do we have, sometimes it's called freedom to operate? Am I going to infringe someone else's patent if I make this or do this? And someone will pipe up. I guarantee someone will pipe up and go, don't worry about it. We have a patent on that. Okay? That is not good. That is not good because your right with your patent is a right to exclude. It's not a right to make whatever you want to do or do whatever you want to do. Okay? You could well be infringing other people's patents. So the mere fact you have a patent does not mean you can go ahead and do it. You just have a right to exclude others. If you're in business long enough, you will hear someone say this. And you're going to jump up because now you're really knowledgeable and you can say, wait a minute, that's not right. We've really got to decide what to do before we get into an infringement case. Okay, last point is patents are territorial. You have to get a patent for every country where you want to have your right of exclusion. Okay, so you can file in the United States. You have it just for the United States. You can file in Germany or you can file in France. This is going to change a little bit where Europe is looking by 2015 to have a European-wide patent that will be enforceable across 18 to 20 countries. That's coming, but it's still territorial. It's still those countries. Okay. But typically, as of today, you have to do it on a country-by-country basis, which is pretty expensive. So we only tend to file where you really think you are going to get revenue. Okay. What's your period of exclusivity? 20 years from the filing date. And I'm going to talk a little bit about filing dates. Filing dates are very important when we talk about patents. They have a whole bunch of critical factors to them. One is they set your term, the other is they set the prior art. And we'll talk about what that means. The U.S. is now a first-to-file system. We used to be a first-to-invent system for a long time, but now we're first-to-file. The rest of the world is first-to-file. First-to-file says the first person to the patent office with the idea, with the invention, wins. Okay? So speed now matters. It always did matter, but speed matters. You need to get there first. You don't want to delay. Okay, so we're now like everybody else, first to file. The old system was if you could prove you invented before the person who filed first, you could get the patent. Honestly, there were less than 100 cases a year where that mattered, and most of the time, if you weren't first, you still lost. So all we've done is really clear up sort of a weird messiness in the U.S. system. Now, public disclosure. Part of the requirement for patentability is what's called novelty, and we'll go into some examples of that. Novelty also includes your own public disclosures. You do not want to disclose your inventions publicly before you file with the patent office. Okay? That's a big no-no. You want to file them first with the patent office before you do a public disclosure. So what's a public disclosure? I submit my paper. I give a presentation. Now, in some cases, if let's say you want to go work with a company, you can put a non-disclosure agreement in place, keeps it confidential, and you don't have this problem. But you want to avoid a public disclosure. Okay? Destroys all your foreign patent rights. The U.S. still has this quirk where you have a year from a public disclosure to file in the U.S., but then you would only have U.S. rights. And U.S. is the only country that has that exception. Okay, so again, it's really a carryover from our first-to-invent system. Okay, so what does it take to get a patent? What's it take to get a patent? The patent examination manual is this incredible document. It runs thousands of pages with more technical details and rules than anyone should ever be subject to. It will cure any form of insomnia. But it's interesting, within that manual, there's really only two substantive rules. A lot of minor rules around it and how you apply it and what do you do with it, but there's really only two substantive rules. The first is it new? We call that novelty. And the second is it obvious? We tend to use it interchangeably, obvious or non-obviousness. Okay? Is it non-obvious? Is it obvious? Okay? And the way we describe it's actually a term of art. Would it be obvious to one of ordinary skill in the art? So what we do is we actually sort of create this straw person who is someone who generates that kind of technology. And we decide what their background is and what would be obvious to them. So in microbiology, it might be with someone with a PhD. If it's furniture, it might be someone who graduated high school. And we have these different sort of one of ordinary skill in the art, and then we decide, is it obvious to them? So let's make a real example to help make this concrete, okay? And this is still the best example. I apologize to people who heard it once, but hopefully you'll get some more subtlety out of it the second time. Let's go back in time, and we're going to go really far back in time, long before we had lovely chairs like here. And we used to sit around fires on rocks and logs. And someone decided that sitting on rocks and logs was kind of uncomfortable, and they were really hard to move when the wind shifted. So they decided they're going to invent the first stool. And the stool is going to have a horizontal seating surface and 4 downwardly extending legs. And everyone goes, wow, that's a great thing. I really like this stool. So they decide, okay, I'm going to apply for a patent on my stool. So they write this thing up and they send it off to the patent office. And the patent office says, well, I got all these rules, but there's only 2 that really matter. One, is it new? So they look at it and they go, okay, is the stool new? Well, the prior art that came before were rocks and logs. So we've never seen anything like a stool before, so it's new. Then the question is it obvious? To people who sit on things, was this an obvious change? And the answer is, well, up to now, all we've ever seen are rocks and logs. We never saw anything that looked like this. So it seems pretty unusual. We're going to say it wasn't obvious to anybody. We're going to give you a patent on the first stool. Okay? So it passed the 2 standards. Someone looks at the stool and says, I like that stool, but when I sat on it, it broke. I'm a really big guy and the stool broke. So what I'm going to do is I'm going to take the stool and I'm going to add a leg, and I'm going to have a horizontal seating surface with 5 downwardly extending legs. And I'm going to get a patent on that. So they write up their patent application, they send it off to the patent office. The patent office says, all right, I'm going to apply my 2 rules. Rule number 1, is it new? Is it novel? Well, what came before was a 4-legged stool, and this is a 5-legged stool. Okay? So it's new. It passes the first hurdle. Then we get to the second hurdle. Is it obvious? Okay, well, we've had a 4-legged stool, and now we've got a 5-legged stool. But it has this advantage that it's stronger, and people can sit, bigger people can sit on it. So we're going to say, you know what, that does seem kind of unique. It doesn't seem obvious to add another leg. So we're going to give you a patent on the 5-legged stool. Next person comes along, is really big, sits on the 5-legged stool, breaks it, and says, I'm going to really go all out here. I'm going to make a 6-legged stool. And they decide they're going to file a patent on it. They fill out their application, send it to the patent office. Patent office takes it, says, I'm going to apply my 2 rules. Is it new? Well, we've had 4-legged and we've had 5-legged stools. And now we've got a 6-legged. But we've never seen a 6-legged, so it's new. It's novel. However, now we have the second hurdle. Is it obvious? So we look at the stool and we go, you know what? We had a 4-legged stool and we added a leg to make it stronger and made a 5-legged. Well, adding one more leg just seems like the same kind of thing. For people who make stools, it seems kind of obvious to just keep adding legs. So we're not going to give you a patent on the 6-legged stool, nor are we going to give you a patent on the 7 or the 8 or the 9. Even though nobody made them, it's pretty obvious that you can keep adding legs to stools. Okay? So those are how the 2 rules interact. Now here comes the subtlety and the exciting part of patent law. Is if it was just that simple, it wouldn't be so fun. Here's the good part. Someone comes along, looks at the 4-legged stool and says, you know what? I'm going to saw off one of the legs. Okay, I'm going to saw off a leg. So I've got a 3-legged stool. I'm going to write up my patent application, I send it in. Have we seen a 3-legged stool before? The patent office says, no, it's new, it's novel. 3-legged stool. All right, now we get to the obviousness question. Is it obvious to have a 3-legged stool? Well, we had a 4-legged, we had a 5-legged, someone made a 6-legged, so maybe changing legs on stools is obvious. However, the patent attorney who's written up this case goes and argues to the patent office and says, wait a minute, there's an unexpected result of a 3-legged stool. It never wobbles. It's always stable. No matter where I put the 3-legged stool, it doesn't wobble. 4-legged stool, 5-legged stool, they all have to be on flat surfaces. But the 3-legged stool doesn't wobble. That's an unexpected result. There's some improvement. We didn't expect that. And that moves it from obvious to non-obvious. Yeah, we're going to give you a patent on the 3-legged stool. Okay? So that's how these rules kind of interact with each other. All the other stuff that you see from the patent office is all about formalities and this and that, and sometimes it's about whether I can patent it at all because it's an algorithm or a medical testing, whatever it be. But most of it really comes down to these 2 rules. And most of the argument, 90% of the argument you make with the patent office is around these 2 rules in concept. Okay. All right, so did everyone get a copy? If not, we can, maybe, Tom, could you grab some extras and just pass them out? Yes, fire away.
The disclosure one is a little bit complicated. So if you disclose, then that then abolishes your patent rights. But what if somebody else then takes your disclosure and files a patent on it?
Well, what would happen in that case is that your disclosure, which is earlier, is prior art against their disclosure. So they cannot get a patent. And often what happens in the corporate world, sometimes what's called, it's sort of proactive disclosure. I don't want to spend $10,000 or $20,000 getting a patent on this, but I don't really want my competitor to get it. So what I do is if I publish it, I now destroy their ability to get a patent too. And so companies will often do that. You can do strategic disclosure for that reason. Okay, and Kodak and Xerox used to both have publications that were deliberately done for that. I know there used to be copies, I think even here at the U of R of them, and it was called the Xerox Disclosure Journal. The whole point was to make it public so you destroyed anyone else's patent rights. Yes, I saw another question? Yes.
So when that happens, it's free game, anybody?
It's free games. Now, it's now out in the public domain. Everybody can do it. Okay? So what I did was I just took the couple of pages from a patent. I left out a bunch of the stuff in the middle because I didn't want to cut down too many trees. And it's just really, this is what, if you haven't seen one, this is kind of what a published issued patent looks like. Okay, and it's got a very set form to it. And there's a lot of information on here. If you come back in December, I'm going to spend a whole bunch of time talking about all the incredible things we can learn from the disclosed prior art and these technical categories. We're going to talk about 15, 20 minutes about that. It's actually quite exciting. But just as an overview, these are the standard parts of the patent application. There's a title, so everything has a title. There's a background of the invention. If you open it up, this one says background of the invention. Now, I put in background of the invention. It's actually considered bad practice now to say background of the invention. It should just say background. There's a summary, okay, which is just kind of summarize what's the invention. And then there's a detailed description, most of which I've left out of here, okay, and a lot of the figures, which is this incredibly technical description of what it takes to do the invention, okay? And then there's claims. We're going to talk specifically about claims because they're kind of the most interesting part of the whole case. Figures and an abstract, all right? So there's a lot of packed in here. The standard application will have all of these things. Sometimes they don't have figures because there's no way to draw something, but most of the time they will. So all of that goes in there, okay? So if you are an inventor, at some point along the way, you will get a draft application that will have all of these things in it, okay? Now, here's my cautionary practice note. Because again, this is the second thing that will happen. The first thing is someone will think that because they have a patent, they can go ahead and do whatever they want. The second thing that someone will do is they'll be asked as a scientist or a junior engineer or something to go read some patents by the competitor. And you read this thing and you go, oh my God, this is just what we are doing. We must be infringing this patent. And then you write this in an email and you send it off. And it comes to the patent attorney, and the patent attorney dies a little inside when he reads this thing because it's actually not true. You have all of this information, often including this detailed description of the preferred embodiment. That is a very broad description of what's going on. The claims are what's actually the right of exclusion, and we'll talk about those. They're very narrow, and they may be very narrow. And to interpret a claim, to decide what a patent covers, you have to have the entire file history of everything that was done with the patent office. You have to look at all the prior art that was cited, plus have a general knowledge of all the technology. Plus you have to apply all the rules that come from the patent examination manual, this giant thing. Plus you also have to understand how all of this gets interpreted by courts and all of the case history, going back in some cases 150 years, on how we interpret claims. Don't ever, 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 ever write a note saying, I think we infringe. Unless you've done all those things, you have no idea whether you infringe. And it's not an insult, but it does mean that you need to have all the legal and technical and all the background in order to make that determination. Yes?
So is your point that you don't have a basis for drawing a conclusion, or that you create a future litigation problem by putting an email inside your company to somebody important that you think...
You do both. You do both, and let me tell you, there's cases where the technology is really confusing, and the poor jury, because you get a jury of just people off the street, mostly retired, because they're the only people who can spend 6 weeks going to a patent trial. Let me tell you, 6 weeks of a patent trial is about the most boring experience you could ever have in your life. And they sit there and they're flooded with all this technical information, and someone stands up and goes, hey, look at this email, they said they infringed. And the jury goes, oh my God, thank God, we'll just depend on that and let everything else go. Don't laugh, cases get decided like that. So what you want is you don't want some crazy record that's wrong. If you have a concern, you pick up the phone and you call somebody. You don't want a paper trail. If you're worried about it, call somebody up. 99% of the time, I or someone else looks at it and goes, you don't have a thing to worry about. Okay? But you don't want that on a record. Okay, so that's just a good practice point. Part of what I try to do is, anyone ever heard of a CLM? It's called a career limiting move. You want to not engage in career limiting moves. So some of this is just avoiding career limiting moves. Okay, so part of this presentation is thinking about you as potential inventors. And you have a really important role in this process. And there's a number of things you do as an inventor. And we'll go through some of those. One, you get a draft of the application. Okay? You have to understand it. Often, you send these things out to inventors and they go, I'm busy, I'm not going to read it. You have to read it. Actually, you declare and swear that you read it. You have to advocate for your application. If you don't like what's written in there, you think it's wrong, you come back and you complain. I hear complaints all the time. I don't mind hearing complaints. If it's wrong or it's incorrect, that's kind of my job. We're supposed to correct it. So I expect that. We, as a university, do pick attorneys who are technically skilled in your art. There is no way in the world that I could know all the technologies that are here at the university. We're trying to hire someone to take at least half of the technologies, but even those, the half that remain, there's no way in the world I will know them all. We do go out and try and find outside patent counsel who do have expertise. So that's part of our goal, and we hope they're good. If they're not, let us know. We'll work together. Okay? And the other thing is you have to trust the attorneys a bit. They understand what all the legal requirements are. Often I get pushback, and the answer is that's a legal requirement. That's the way claims are drafted. I know it doesn't, that seems kind of crazy, but that's the way the patent office works. So some of that is you have to give us a little slack. We're bringing our expertise, you're bringing your expertise. Okay? And part of it is just, when you look at the application, it is for the patent examiner, mostly, but there is potential that it could be for a jury, a judge, and all kinds of people. So you want it to be clear, you want it to be understandable. They tend to be highly technical. The claims don't remotely look like anything ever written in English, but we do try our best. But you're an important part of the quality control. If you don't invest your time, we won't have good cases. It really, really depends upon you as inventors to put your time and energy in. We get much better cases when you do. Okay. We're doing that's good. Okay. There are a set of formal papers that as an inventor, you need to perform as part of the patenting process. One's called the declaration, and the declaration is I declare I'm an inventor of the subject matter of at least one claim. Patents are kind of interesting. If you are an inventor of at least one claim, there could be 100 claims in the case, and you contributed to one claim, you have an undivided interest. You are equal to all the other inventors. Within patent law, there's no distinction of, well, they did most of it, so they get most of the credit, or they get most. Patent law says you all have an undivided interest. Okay? And what that means is each of you can go off independently and do what you want with the patent. You don't even have to account to each other. This occasionally happens. People invent together and then they have a falling out. You both have an undivided interest, and you both go out and try and license on your own. Now what happens is savvy licensees come to you and get, oh, I'll license from you for 5%, and then they go to the next guy and they say, you know what, I'll license from you for 4%, but you wouldn't get anything if I do it for 5 from him. And so what you do is you get sort of a game to the bottom. And that actually happens. But as the inventor, you declare that you are the inventor. Under the Constitution, only you as the inventor are allowed to apply for the patent. So we need to have you do it. Now, on the other hand, if you are the uncooperative inventor, we have that occasionally happen, you decide you don't like us, or you leave under bad circumstances, or you die. There is a process to take care of this when we don't. But we do hope that you are cooperative. As grad students, professors, and everything else, including myself, we are all obligated to assign we are all obligated as part of this to preserve these rights. So you don't want to have any deliberate misrepresentation, and deliberate misrepresentation invalidates the patent. How does this typically happen? Usually that happens when there are too many inventors, or more often when there's too few inventors. I can't tell you how many times I've had people come to me and say, you know, we were working with this guy, but he left. Take his name off the patent. You can't do that. If you are an inventor, you are an inventor. The fact that you left the university, or the other grad student left, or the professor left, and now you want to take him off, none of that matters. If you are an inventor, you are an inventor, whatever the circumstances may be. So don't come and ask to remove people who you don't like, either because you're having a personal tiff with them, or because they've left the university. Don't laugh. This happens. This happens. And that actually does invalidate the patent, should it occur. Okay. So, the last thing as an inventor that you have to really worry about is what's called the information disclosure statement. I'm sorry, this is incredibly wordy. What it boils down to is that you have a positive obligation, often because as the inventor, you're most aware of what's already out there. So you have a positive obligation, as do I, the patent attorney, as does our outside counsel, that if we are aware of any prior art, we have a positive obligation to disclose it to the patent office. Okay? Failure to disclose can invalidate the patent. Okay? And often, just from a practical standpoint, if we don't disclose it now and you get claims, you get a patent. If we ever got in litigation, it will be found, because the 10 hours the examiner spends looking for prior art will be multiplied by 100 or 1,000 by the other litigants. And whatever you think you've hidden will show up, and now the claims will be invalid, and it will have all been wasted effort. It's better to have it up front, get the scope of the claims the best you can given the circumstances, and now you have a really strong patent. So we all have this positive obligation. Okay? And it's called material to the patentability. Does it seem related? I mean, it's a fancy term of art, but it's sort of practical. Okay? All right. What do I have to put into my patent application? Your patent application has to be what's called enabling. It's a requirement. It's enablement. And the way I like to think about this idea is that mere ideas are not patentable. You have to enable your idea. It has to have some reduction to practice in order for it to be an actual invention. So I can have the idea that I would like to fly to the moon. Okay? Fly to the moon. I'm going to file a patent application on flying to the moon. They're going to get it, and they're going to say there's no enablement. How do you do it? Okay. So maybe now I go, well, I'm going to have a rocket, and I'm going to have a capsule on top of the rocket, and I'm going to put some air in there, so when I'm up in space, I'll have something to breathe. And they go, okay, now you're starting to sound like something that's enabled. I could start to think about giving you a patent for this idea. Or maybe it's I'm going to put myself in a giant slingshot, or I'm going to fire myself out of a cannon. But those are all ways of enabling flying to the moon. Often people have ideas of things they would like to do. Wouldn't it be great if we could do this? But then you have to think, well, how do I do it? And that's really the enablement requirement. And often, if you look at our invention disclosure form, we're sort of asking you for the idea, but what we're really also going to, if we're going to go further, is how do you do it? What's the enablement? Now, the interesting part is you don't actually have to have done it. You don't actually have to build the rocket. You just have to be able to describe it well enough that someone of ordinary skill in the art could build it if they had to. Okay? So you actually don't have to build it. Okay? Now, there used to be a requirement with the patent office that you actually had to build a model of whatever you were going to patent. That's not a requirement anymore. So you can, as long as you can describe it well enough, even if you haven't done it, that's sufficient. So enablement does not mean I've actually done it, but it means I know how to do it, and I could tell someone with reasonable degree that they could do it too. Okay, so that's really enablement. So it's not a blueprint, but it's more than just an idea. Okay. So I keep talking about the filing date being this really critical piece of place in the process. Okay, we're doing pretty well on time. Why is it important? It's 20 years from your filing date. That's the term of your patent. Okay. It used to be 17 years from when your patent issued, but patent trolls would let their cases roll around in the patent office for 30 years and then have them issued. So we decided this was sort of the most efficient way to get around this problem. Your filing has to precede any public disclosure, because if you give a public disclosure, that's prior art now. And remember, now you fail on the novelty. Is it new? It's not new. It's already out in the public domain, even if it came from you. Sort of frustrating. Okay. But the most important part about the filing date is it sets what's called often your priority date. Okay. And if you look sometimes at a patent, I'm not sure, I forgot to see if this one was the same. If you take out this case, it was filed on February 15th, 2006. Okay. When you come back to the other presentation, I'll have one that'll have a bunch of crazy continuation cases and everything else. The priority date will be you'll have to go back and figure out what it is. What's magic about that date? What's magic about that February date in 2006 is that when we decide if the patent is novel and non-obvious, we can only look at art that existed prior to that date. What was public and existed prior to that date? Anything that comes after is not prior art and isn't held against your application. Okay? So it's the magic date. It literally draws the line in the sand. Everything that came before, I have to overcome in terms of patentability. Anything that comes after, I don't have to worry about. So it's a very important date. Okay. So what is prior art? Anything that's in the public domain. Publications, patents, theses, sales literature, service manuals, machines, offers to sell, government submissions. So if you submit your paper for a grant and it's not under some type of confidentiality, that will count. Talks, any sort of public talk, particularly now with YouTube, anything that's on YouTube, that's going to be all considered prior art. And it just has to be the most minor public disclosure. There's a famous case where the prior art that knocked out the patent was a PhD thesis in an Australian library at a university. There were 2 copies of it. Think about some poor grad student slaving away on their doctoral dissertation. They made 2 copies. It ended up in an Australian university. It was discovered when there was a litigation, but it was publicly available. The fact that it was there was irrelevant. The fact that it was written in German or Swahili or any other language, it would be irrelevant. Language doesn't matter. Location doesn't matter. As long as it's before that date and publicly available, it's all fair game. Okay? So it's much broader than you think. Okay? And again, don't forget, it also includes your own public disclosure. That's why you want to be careful. You don't want to, by your own mistakes, destroy your patent rights.
If geography doesn't matter, why do so many countries have their own patent offices?
Well, because remember, patents are territorial. So you get that right of exclusion by country. So basically every country has its own patent office to give you that right of exclusion. And that's part of the problem with patenting is an expensive process because you have to literally do it country by country. So it may easily cost $20,000 to do a patent in the US. Actually, the US is one of the cheaper places. But then if you go to another country, often you have to do a translation. You now have to pay for foreign counsel to prosecute the case. Most other countries have a very expensive, frankly, it's called annuity fees, but frankly, it's a tax. Every year you have to pay a tax to keep your patent in force. That's often why patents lapse, because it's too expensive to keep them going. In most countries, that amount goes up year after year. It's not unusual. I get a form that looks at our patent portfolio, and I'll look at some of our foreign cases, and to keep them in force for the life of the patent can easily, in some cases, cost $35,000 to $40,000. Just to keep them in force. That doesn't include the cost to get it from day one. So you could easily be $60,000 in the hole before you even start, if you try.
Prior art is universal, but the administration process is
Is territorial. It's by country. Again, and there'll be a slight difference. Europe is going to a somewhat unified system, both in terms of there will be a European patent if you wish to pay for it, and there will be a European examination and enforcement system if you choose to use it. Okay? So, talk about claims. This is the most important part of the patent, and this is kind of going to be the last big point that we talk about. They're the heart of the patent. They define the scope of your right of exclusion. Okay, so they define the scope of the patented invention. The way to think about it is if you've ever bought a house, you get a deed, and the deed lays out the metes and bounds, basically lays out the boundaries of what you own. Okay? Everything within the boundaries is yours. Everything outside of the boundary, you have no rights to. Okay? So the claims are trying to do that. Now, claims are these weird things. They have strange formalities to them. I have a claim here. By practice, they're written in one sentence. Don't ask me why. They're one sentence. They have what's called a preamble. So this is a method of placing an order for an item comprising. Okay, that's called the preamble. Sort of sets up the environment in which the invention is going to reside. Typically, the preamble does not limit the claim. The word comprising is a very important term of art. It says comprising means these elements, but there may be more. So this isn't an exclusive list. This just says in terms of infringement, you have to have this minimum. There may be other items. So like when I said the stool, a horizontal seating surface with 4 downwardly extending legs. If you had a 5-legged stool, it has a horizontal seating surface and it has at least 4 downwardly extending legs. It actually infringes. Okay, it's at least as. Sometimes, particularly in the chemical arts, you will see consisting of. The preamble and it will say consisting. Consisting is limited. It says only the things that are listed. It tends to show up in the chemical arts where you don't want impurities or something else. But the vast majority of claims you'll see comprising. It's basically a word that just says wide open, anything else. Okay, and then we get what are called the series of limitations or the elements of the claim. So this one is comprising under the control of a client system, displaying information, identifying the item. Okay, this is sort of a method claim. In response to only a single action being performed, sending a request to order the item along an identifier of a purchaser, along with an identifier of a purchaser. These are all starting to be elements. If I was going to decide if someone was infringing this claim, I would have to find in their system every one of these things. I'd have to find a client system. I'd have to show that they displayed. I'd have to see that they performed only a single action. See, this is limiting, only a single action. Okay. Sending a request, identifying the purchaser. Okay. I would look for all of these elements. Now, when this claim was examined, the patent examiner looked in the prior art and said, can I find all these elements in the prior art? Can I find it in one item? That would mean it fails on novelty. Or maybe I need to combine a couple of references, a couple of things in the prior art to get all of the elements. Anyone recognize this claim?
It's the Apple Pay that's just been
No?
introduced.
No. Predates that a bit. Close. It's the Amazon one-click patent. Everyone kept going, how can someone get a patent on clicking and buying something? Okay, everybody thought, that seems really dumb. How can I get a patent on that? But actually, this is a great claim. I think this is an extremely well-written claim. And it's not just on clicking to buy an item. You can see you have to have identifiers of the purchaser, you have to display the item, you have to have a component system, you receive it, all of this goes on over the web, you retrieve information that's been stored. You start to see that there are all these steps, and when you go through this whole thing, you start to think to yourself, yeah, that is novel. You had to have all these elements come together, and all of them have to happen in a certain sequence in order for this to occur. Okay, and then finally, fulfilling the generated order to complete the purchase of the item. Okay, so you send it to them. All right?
Do you expect Apple will have to pay a license?
I'm not sure. Well, it depends how they run their system. Do they meet the limitations of this claim? I'm not quite sure how the Apple system is going to work. Apple's very excited about this because they're going to get like 0.5% off everything you buy. It's a fabulous moneymaker for them. Okay, so that's a claim. Okay? Now, if you look again at the sheet I gave you, if we turn to the last page, the back page, we have what is claimed. These are the claims of this patent. Okay? An adjustable hydraulic valve lifter. I'm a car guy, so I like this kind of stuff. And it gives a set of limitations for this hydraulic valve lifter. Okay? That first claim, the first claim of any patent is called an independent claim. It basically stands by itself. Okay? Then we can see claim 2 is an adjustable hydraulic valve lifter of claim 1, further comprising, so we're going to add something to this. The motor for rotating the internal cylindrical body. Okay? So now what we've done is we've added another element. Okay? So we have an independent claim, and now we've added another element. What we've done actually is we've shrunk the scope of this claim. People sometimes get confused. They read the claim of your own invention and you go, it doesn't sound like what I invented. I think you didn't describe this, you didn't describe that. Well, every time you add an element, you make the scope of the claim more narrow. So it's about figuring out what is the least amount of things you need to recite to get patentability. So sometimes they look very spare. You're like, well, where's all the other stuff? The other stuff hopefully comes in the dependent claims. You keep adding new things. I think the best way to think about claims is as Venn diagrams. Okay? So we can have an independent claim 1, and it covers a certain territory. Okay? And it's using words to describe technology. Okay? Which is kind of crazy. But that's, again, it's the strangest of claims. And then what we do is we have claims that further limit. So maybe they add an element. They're going to be more narrow, and they'll always fall completely within the independent claim. They're just more narrowing. Now, what you'll often see, and this one is true too, it has a claim 4. Claim 4 starts all over again. It's another independent claim. Recites more components. But it describes them in a different way, and it includes a slightly different combination. So, in this case, you can have another independent claim. So this one I have claim 6. And it itself may have more narrow claims. So you go to yourself, well, why would we go to all this effort to have all these claims? I have an and invention. Why would I have all these claims that are of different scope? And why can't I just have one claim that says what my invention is? And there are some cases that have one claim. They're not good patents, but you could have a patent with one claim. Well, first off, what you're trying to do is cover as much territory as you can while avoiding the prior art. Okay? So, there might be a piece of prior art right here. I can't make this claim broader because it would then read on the prior art. It wouldn't be valid anymore. Okay? But if I write a slightly different claim, I can now get sort of a different scope. I get this kind of overlapping Venn diagram. So I'm trying to cover as much territory as I can. I want the broadest patents because that's the most valuable. Okay? So we use these multiple patents overlapping to try to broaden the scope of what we do. It matters the most if you ever have a case that gets litigated. Now someone's trying to prove my patent is invalid. It's not novel. It's obvious. And what they're going to do is they're going to go out. Remember I said, the examiner spends maybe 7 or 10 hours looking at prior art. They may spend 100, 1,000. They may find prior art I didn't know about. So they may find prior art. They find this piece of prior art that sits right here. My claim reads right on it. Claim 1 reads on it. Claim 2 reads on it. The claim's invalid. However, claim 4 and 3 are narrower. They don't read on that. They're still valid. Claim 6, it didn't read on that. It's still valid. So the reason we have multiple claims of these varying scopes is that we're playing a game. And the game is I don't know what exists out in the world in terms of prior art. There's probably more than I know of. I want to cover as much territory as I can, but I have to be careful that there might be prior art out there that's going to invalidate some of my claims. So I have lots of claims, and I have varying scopes so that it's protected. And what I really hope is that everybody wants to do what's right inside claim 4. That's the part that really people want to do. And so they find prior art, but my claim 4 still lives. Okay? and therefore my patent stands and they infringe. Okay? So that's really the goal here. So the reason you have all these claims, because it seems confusing, why do I have all this stuff? I have one invention, why do I have all these claims? Because we don't know what the future is going to bring. We want as much territory as we can, that creates value, but if it ever came up that there was art, then we would be able to protect ourselves. Okay, we're pretty much at the end here. Just going to finish with a quick couple slides, and then I'll do a little pitch for the rest of this. Enforcement in the U.S. begins on issuance. You have to have the patent issue. So up until that moment, people can infringe your patents. This does happen. You send them nice letters saying, oh, by the way, my patent's going to issue. I hope you're not infringing on the day it issues. You better be careful on the day it issues. People write letters like this. It's kind of fun to write them. On the day it issues, now you have a right to exclude. Okay? So it does occasionally happen that people will build industries and then suddenly a patent comes out later. Okay? It's one of those things you have to be careful for. Okay, I say foreign, that means really non-US. There's a kind of an interesting rule that you can file within 1 year of your initial filing anywhere in the world. It's called the Paris Convention. And I get the priority date of my earliest filing. So I could file here on February 2nd, 2014. And as long as I file before February 2nd, 2015, I can file anywhere else in the world, and it's as if I had filed on February 2nd, 2014. Because it recognizes the problem. You can't file simultaneously in patent offices around the world all at the same instant. So it's kind of just a way of allowing the system to work nicely. Okay, we use outside associates for all our U.S. filing. We also do the same thing for overseas. We don't tend to file a lot overseas because it's very expensive. You have to translate. The costs are very high. In the corporate world, you typically file either where you have a big market or where your biggest competitor is likely to manufacture or have their biggest sales. Okay, so that's typically how you decide. And patent enforcement, U.S. tends to be the biggest place for patent enforcement. We are far bigger than anywhere else in the world. We have a very robust patent system. We tend to be a big market. We tend to give high levels of rewards for patent infringement. So if you're going to spend your money on litigation, it's a good place to do it. Okay? And if someone is really egregious in their patent infringement, you can actually get up to treble damages plus your attorney's fees. So that can really pile up. Okay. All right. So finish with this. This is the last slide, and then I'm going to do a little pitch. Keep your inventions confidential. You don't want to lose your patent rights. Okay. Timeliness matters. First to file system. We want to get to the patent office quick. Don't forget this. It's not a right to use. It's only a right to exclude. You have to have an agreement in place to get the rights of patentable inventions. Remember, the inventor owns the invention. Short of an agreement that they assign it to someone, that does not happen. There has to be an actual agreement. Okay? So it is true that in the real world, you could go out to somebody and give them a bunch of money and say, I want you to create something for me. They create a new invention. You take it, you start manufacturing it, and they come back later and say, oh, by the way, I'm the owner of that invention. We didn't have any agreement that I assigned it. You owe me a royalty. That actually happens. Okay, that's why you want to be careful. You don't want to find yourself in that place. And don't give away your rights. I say this really as a representative of the university. It's a little disappointing sometimes to see people come in that they already signed an agreement last year to go work with someone that we didn't see, and they gave away all their patent rights. Okay, we really want to avoid that. It's important for us as a university, it's important for you, it's important for your labs. Okay? Next seminar is Technology and Commercialization. I hope you come back. We have food again, it's at 12, and then we'll finish up this semester with inventions and good inventions. Thank you very much, you've been very patient.